Hello, friend. Today we're going to talk about child assessment order. A child assessment order under Section 43, Children Act 1989, enables a compulsory assessment of the child or children to be made where significant harm is suspected, but the child is not thought to be at immediate risk and the parent have refused to cooperate. Section 43 Children Act provides as follows. Subsection 1. On the application of a local authority or authorized person for an order to be made under this section with respect to a child, the court may make the order, but only if it is satisfied that a. the applicant has reasonable cause to suspect that the child is suffering or is likely to suffer significant harm. B. An assessment of the state of the child's health or development or of the way in which he has been treated is required to enable the applicant to determine whether or not the child is suffering or is likely to suffer significant harm, and C. It is unlikely that such an assessment will be made or be satisfactory in the absence of an order under this section. Subsection 3 states, a court may treat an application under this section as an application for an emergency protection order. Subsection 4 states, no court shall make a child assessment order if it is satisfied A. that there are grounds for making an emergency protection order with respect to the child, and B. that it ought to make such an order rather than a child assessment order. Subsection 5 states that Section 43, subsection 5, it states that a child assessment order shall A. specify the date by which the assessment is to begin, and B. have effect for such period not exceeding 7 days, beginning with that date, as may be specified in the order. Subsection 6 states that where a child assessment order is in force with respect to a child, it shall be the duty of any person who is in a position to produce the child, A. to produce him to such person as may be named in the order, and B. to comply with such directions relating to the assessment of the child as the court thinks fit to specify in the order. Subsection 7 states that a child assessment order authorizes any person carrying out the assessment or any part of the assessment to do so in accordance with the terms of the order. In other words, there is need for strict compliance with the terms of the order. So it is very important to carefully draft the order to ensure that it enables the assessor to do exactly what is required under the child assessment order. We turn to paragraph 43, subsection 8, and this is quite interesting. Subsection 8 states that regardless of subsection 7, which we just mentioned, if the child is of sufficient understanding to make an informed decision, he may refuse to submit to a medical or psychiatric examination or other assessment. Subsection 9 is also important in how the child assessment order is effected or carried out. 43 subsection 9 states, the child may only be kept away from home, A, in accordance with the directions specified in the order. So it's really important to draft the order carefully. Subsection B, if it is necessary for the purpose of the assessment, and B, for such period or periods as may be specified in the order. Again, it goes back to the drafting. It's very important that the order is drafted so that it precisely indicates what they are trying to assess and where it will be done and with whom who will accompany the child, who will be there. Everything needs to be properly put in the order. Otherwise, a parent is entitled to object, or the child. Paragraph 10 then states that subsection 10, rather, that's 43 subsection 10, it states that where the child is to be kept away from home, the order shall contain such directions as the court thinks fit with regards to the contact that he must be allowed to have with other person while away from home. So we see here in 43 subsection 10 that it doesn't leave it to the usual the provision does not leave it to 34 section 34 which deals with contact, but there's specific provision made here under a child assessment order so that contact provision are made and are provided for in the order. Again, the order needs to be carefully prepared to include defined contact. 43 subsection 11 is also key in how the application is made, because this is part of the technicality of any application under section 43. This technicality, local authority need to be mindful of this, because it says any person making an application for a child assessment order shall take such steps as are reasonably practicable to ensure that a notice of the application is given to A, the child's parent, B, any person who is not a parent of his or hers, but who has parental responsibility for the child, C, any other person caring for the child, D, any person named in a child arrangements order as a person with whom the child is to spend time or otherwise have contact. E, any person who is allowed to have contact with the child by virtue of an order under section 34. And F, the child. So we see here that there are 6 category of people potentially who notice need to be served upon in accordance with the provision of section 43 when an application for a child assessment order is made. We're now going to look at the case of REI, open brackets, children, child assessment order reported in 2020 EWCA CIV from page 281. A little bit of the background will enable us to appreciate the case a little bit more. It's an appeal concerning the court's power to make a child assessment order pursuant to Section 43 Children Act 1989. The case concerned 5 children aged 9 to 18 at the time of the appeal. The local authority involved for the family, due to concerns arising from the father's conviction for offences under the Terrorism Act 2000 and the impact of his belief and activities upon the child. The children presented well, and an investigation in 2017 found that the mother was acting protectively. A Section 47 investigation upon the father's release on license in late 2018 raised concern about the mother's protectiveness and recommended a child in need plan. The mother opposed intervention. The children were made subject of child protection plan in early 2019. By mid-2019, the parents revoked their consent to direct work being done with the children. The mother declined to meet prevent or engage with a parenting assessment. In July 2019, a meeting with the local authority recommended assessment by an intervention provider. The parents refused to consent. Thereafter, the pre-proceeding process was initiated with the hope that there would be no need to go into proceedings. Father was recalled to prison in August 2019 and remained in prison. The mother declined to the work proposed under the pre-proceedings or public law outline. In the court of first instance, the local authority applied under Section 43 for the children to be assessed by an intervention provider. The parents and the 4 older children, who by now within those proceedings were separately represented. In other words, they had their own solicitors representing them, as opposed to through the guardian, and they opposed the application. The guardian supported the application. The matter came before Newton J. Heard the case, he accepted the legal argument that as the local authority had placed the children on a child protection plan and activated the pre-proceedings process, its state of mind was one of belief, and therefore the test of Section 43, subsection 1a was not satisfied. Further, Section 43, subsection 1b, and these are the technicalities the court is looking at. 43, subsection 1b was not satisfied, as the assessment was not required for the local authority to determine if the children were suffering significant harm as it already believed they were. So the judge refused the application, determining that he did not have jurisdiction to make the order, and refused the case on the merits. The guardian, supported by the local authority, appealed. The appeal came to the Court of Appeal, and Peter Jackson, Lord Justice, gave the lead judgment. He observed that Section 43 is seldom encountered and considered the few references to it in the case law as well as the statutory guidance. On appeal, only Father sought to uphold the judge's decision on jurisdiction. He asserted that, as a matter of law, the consequence of the local authority's action, such as the calling of a child protection conference, was to make a Section 43 unavailable. The Court of Appeal held that the lower court, Newton J., got the case wrong, or got the decision wrong, or was wrong in law. Section 43 must be read in the context of the legislation as a whole. So you've got to take section 43 as a whole, including all the procedural bits of it. The purpose of this section is to enable proper assessment to establish whether there is a need for further action. Section 43, subsection 1a provides a relatively low threshold of intervention or of reasonable suspicion. This is a threshold to be crossed, not a target to be hit. The normal rule of statutory construction that the greater includes the lesser applies. The proper reason for departing from it, that the court is examining the local authority's state of mind, has no logical foundation. The only restriction on the use of section 43 is, as per section 43 subsection 4, where an EPO, an emergency protection order, should be made instead. An assessment can only be ordered if it is required, i.e. necessary, by virtue of section 43 subsection 1b. Determination of whether a child is suffering or likely to suffer harm is not confined to a yes/no answer. There is an essential qualitative character to the assessment process. The interpretation suggested by Father conflicts with good social work practice, flies in the face of proportionality, and would effectively render section 43 redundant. On the merit of the application, it was difficult to be precise as to Newton Jay's reasons. The Court of Appeal found that he could not reasonably have reached his decision on the evidence before him. Of note, Newton Jay had, in effect, substituted for the requirement for reasonable suspicion test a test of whether the local authority has acted reasonably. The proportionality exercise had gone awry. The proportionality exercise has gone awry. The Court of Appeal rejected the father's contention that section 43 does not permit an assessment of the children's religious faith, as it is not a facet of the health, development, or treatment by their parent as self-evidently unsound. The assessment was of the children's vulnerability and resilience in the face of extremist propaganda masquerading as religious faith. The court preferred Newton Jay's approach that the opposition of the children was not an obstacle to the making of an order, to the arbiter remarks of. We shall now turn to the court's decision. The appeal was allowed. The Court of Appeal made the child assessment order. They expressed the hope that the children would engage with it, noting that the older children had the right to refuse. We shall now talk about the variation, whether the order can be varied or discharged. The order, a child assessment order, can be varied or discharged on application by the local authority or persons specified in section 43 subsection 11 in accordance with the court rules in section 43 subsection 12. I think there's something I need to mention about appeals. The same person who can apply for the variation or discharge may appeal against the making or the refusal to make the order. There is no appeal if the court makes an emergency protection order. It's worth mentioning as well, with regards to the hearing, that the children's guardian may be appointed in the proceedings where there is a conflict between the child and the children's guardian. Both can be legally represented. We're now going to turn to evidence. Any statement made concerning the upbringing, maintenance, or welfare of a child, it is admissible, notwithstanding any rule against hearsay, and that's in Admissibility of Hearsay Evidence Order 1991. I hope you have found this helpful in your understanding of Child Assessment Order.